Wayfarer just filed a response about the whole MJOP drama and request for admission. It's a good one. I made myself teeny tiny here because I think it's worth a read. I think everyone should read it. It's written in a way that's understandable by a lot of people, most people. But essentially what they do is they first hit the timeliness argument and talk about Rule 12C, which is the rule under which a motion for judgment on the pleadings can be made. Talk about how it can be filed early and it can be filed late so long as it doesn't delay trial. And even provide an example of a case where it happened in the midst of partial summary judgments being granted. They address the claim made by Lively's counsel that the Wayfarer parties sat on their motion for nearly 9 months. But they point out that actually the operative complaint, so the operative complaint means the one that's, there was the first complaint, it got amended, and then it gets amended again. So we're at the second amended complaint. That's the operative complaint, is the second amended complaint. And they note that the second amended complaint was only filed 2 months ago. Anytime there is an amended complaint, even if it's a small amendment, a party has to answer it, has to respond to it. So we're talking about something that was only really operative as of 2 months ago. They knew that the Wayfarer parties had to answer it in some format. So this is not necessarily sitting on any right that they had. Next, they talk about how the MJOP is actually in the name of efficiency, is actually in the name of judicial efficiency. Talked about that in a previous video. What the MJOP does is it narrows the claims down to the ones where they're legally viable to be brought before the court, before a jury. So the judge at this stage only has to look at the law, only has to decide whether or not the claims can be brought under the law. Once those claims are narrowed to the ones that can be brought under the law, those cases can be adjudicated through a summary judgment, at which point evidence can be considered. This is a repeat of what I said in my prior video, but that's essentially what they're saying here. It's almost like Kevin Fritz saw my video. Just kidding, that poor guy probably has no time for TikTok, let's be real. But it's exactly what I said in my prior video. How does amassing evidence have anything to do with an MJOP? That's not the standard. The standard is whether or not you can bring a claim under the law. That's it. So it doesn't matter whether or not discovery is ongoing or not. This is a legal question. This is one that should be adjudicated before summary judgment. No judge wants to decide a summary judgment motion on 15 claims when they can decide it on 5. Next, they talk about the alternative relief sought, which is an extension of the deadline to oppose the MJOP. The Wayfarer parties say, no, recall that while discovery was going on, the Wayfarer parties had to oppose motions to dismiss as well as numerous motions for sanctions against the Wayfarer parties and their counsel filed by Lively and her husband, Ryan Reynolds. So they've been opposing motions left and right during discovery, but suddenly Lively can't oppose a motion during discovery? Additionally, they say that extending the deadline to respond to the MJOP is actually going to make it close to the summary judgment motion deadline, and that is not ideal either for any of the parties. So for those reasons, the extension of time should be denied. Next, Wayfarer requests that the court amend the case management plan and scheduling order because of issues that are arising in completing discovery. As it stands now, the parties are required to file summary judgment motions to the extent that they want to before expert discovery is completed. And so here the Wayfarer parties are saying that it would behoove the court and the parties to have that summary judgment deadline after the expert discovery is completed. They're asking for more time also because apparently Lively has shifted her theory of damages, and their experts are going to need to continue to analyze that before expert discovery is completed. So that is the basis for why they're asking for more time. I think it's reasonable. More time would apply to both sides here. So it's an amendment of the deadlines for both sides completely. And it behooves the court to allow both sides to be able to complete that discovery before summary judgments are filed. The only thing I can think of that the judge might be frustrated with is the fact that the deadline to file a summary judgment motion is December 15th. He might say that that's too close to the holidays, that it won't get resolved, but I still don't think that that would be a problem because trial is not until the end of March. So that's months. Now, it will take a long time to get a answer on the summary judgment motion, especially given there's all these other motions going on. So there might be a question at the hearing tomorrow about, is March still a feasible trial date? So it will be interesting to hear from the Wayfarer party side how they perceive that this wouldn't be a problem. I don't think it's cutting it that close, but I can see a judge being more conservative on that date. Last but not least, they address the request for admission extension to be denied. They point out that the deadline passed 6 weeks ago, and they're only now asking for this extension, which is sort of improper if you think about it. They should have asked for it 6 weeks ago. Now they're only asking about it now. And on that grounds, it's just far too delayed. Why are you asking for these now? It's almost like asking to reopen discovery. They didn't explain why they didn't ask for it sooner, and the Wayfarer parties have been dinged for that. Remember Isabel Ferrer? So curious how the judge is going to rule on that. That's it for that. If you're attending the hearing tomorrow by telephonic conference, here's the information. Screenshot it, keep it. If you want to attend, you can attend via phone. You'll only be able to hear, you won't be able to talk, you won't be able to see. I will be doing that. I will be trying to listen in on most of the call, even though I have work tomorrow. If you have any predictions about what's going to be asked of the parties, you can drop them in the comments. We can see what you guys think is going to happen tomorrow. Once it's completed and once I've digested what's happened, I will try and give a recap.